So, imagine this. You've ticked all the boxes. You've got your offer, your acceptance, consideration, intention to create legal relations. It all looks perfect. But what happens if that whole agreement was based on a huge misunderstanding? Or what if one of the parties was basically forced into signing it? And that is exactly where vitiating factors come in. They question the most fundamental part of any contract. Was the consent genuine?
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Today, we're diving into something that is absolutely critical for your contract law studies: vitiating factors. You can think of them as the hidden cracks in the foundation of a contract. The things that can make a deal that looks perfectly solid just completely crumble. We're going to break down exactly what they are and, more importantly, how you can spot them. Okay, here's the game plan for today. First, we'll get a handle on what it means for an agreement to go wrong. Then we'll tackle the big three: mistake, then the different types of pressure, and finally, illegality. And to make sure it all sticks, we'll finish up with some SQE-style practice questions. Let's get into it. So, what on earth is a vitiating factor? Well, the word vitiate is just a fancy legal term that means to spoil or impair the quality of something. So, in contract law, these factors are things that spoil the consent that was given. They mess with the agreement so badly that it might not be enforceable at all. Okay, this diagram is super helpful. It lays it all out for us. What I really want you to focus on are the two possible outcomes: void or voidable. Getting this distinction is crucial for the exam. A void contract is basically a ghost. It's a total nullity in the eyes of the law, treated as if it never ever existed. But a voidable contract is different. It's a real valid contract, but the innocent party has a choice. They can either stick with it or they can hit the eject button and cancel it. It's got a built-in escape hatch. Right, let's kick things off with mistake. And I want to be super clear here. We're not talking about just making a bad deal or having buyer's remorse. In law, mistake means the parties were so fundamentally confused that they never really agreed on the same thing. There was no meeting of the minds, so no genuine agreement was ever actually formed in the first place. Okay, the first type of mistake we need to get our heads around is mutual mistake. The easiest way to think about this is that the parties are talking past each other. They both made a mistake, but they made different mistakes. It's like two people are having a conversation, they're both using the same words, but they're thinking about completely different things. The law calls this being at cross purposes. And the case everyone, and I mean everyone learns for this, is a classic from 1864, Raffles v. Wishelhouse. The deal was for a shipment of cotton on a ship called the Peerless. Simple, right? Wrong. Turns out there were two ships named Peerless leaving from the same port, one in October and one in December. The buyer thought he was buying the cotton on the October ship. The seller thought they were selling the cotton on the December one. Because the contract was so ambiguous, a reasonable, objective person couldn't possibly say which ship they meant, so the court said there was no contract. It was void. Okay, let's bring this into the modern world. How would this work in an exam question? A tech firm orders the latest model server. The problem is the supplier has two different product lines, and both have a latest model. The supplier sends the pricey one, but the tech firm wanted the other one. Well, just like in Raffles, the term "the latest model server" is so ambiguous that a reasonable person can't know what was agreed. So there's no contract. It's void for mutual mistake. All right, next up is unilateral mistake, and this is a whole different ballgame. Here, only one person is mistaken, but, and this is the absolute key, the other party knows they're making a mistake, or they really should know and they say nothing. They just try to snap up the deal and take advantage. Our really big deal in unilateral mistake is when you're mistaken about who you're actually dealing with, especially when it's not face-to-face. Take Cundy v. Lindsay. A con artist ordered goods by letter, pretending to be a well-respected company located just down the road. The seller shipped the goods, believing they were making a deal with that reputable firm. The court said the contract was void. Why? Because the seller only ever intended to deal with the real company. Their offer was only open to them, not to the fraudster. So no contract with the rogue could ever have existed. It was void from the get-go. Okay, let's shift gears. We're moving away from confusion and mistakes and into the territory of improper pressure. With duress and undue influence, there actually is an agreement. The problem isn't a lack of consensus, it's that one party's consent wasn't freely given. This is a really common point of confusion, so let's nail the difference right now. Duress, it's a direct, illegitimate threat. Sign this contract or I'll break your legs or I'll cancel your supply chain. It's about coercing your will. Undue influence is sneakier. It's not a punch, it's a whisper. It's an abuse of a trusting relationship where someone persuades you to do something that's not in your best interests. So, when it comes to economic duress, which is what you'll see most often in commercial law, the courts have given us a handy 3-step test. You need to hit all 3 for it to stick. First, did the victim have any other realistic choice but to give in? Second, was the pressure illegitimate, like a threat to breach a contract? And third, was that pressure a significant reason why they agreed? Okay, let's run this wedding day disaster scenario through our 3-step test. Step 1, did the couple have a practical choice? No way, their guests are literally arriving. Step 2, was the pressure illegitimate? You bet. Threatening to ruin their wedding day unless they pay more is a textbook example of illegitimate pressure. And step 3, was it a significant cause? 100%. This is a clear-cut case of economic duress, and that new agreement to pay extra is voidable. All right, let's dig into undue influence. Remember, this is about the abuse of a relationship. Now, you can prove it in one of 2 ways. The first is actual undue influence. That's the hard way, where you have to bring specific evidence of the improper pressure. But the more common route, the one you'll see more in exams, is presumed undue influence. This happens automatically in some relationships, like solicitor-client, or in any other relationship where you can prove one person placed a huge amount of trust and confidence in the other. And the go-to case here, which really brings this to life, is Lloyd's Bank v. Bundy. You had an elderly farmer who completely trusted his local bank manager, a relationship built up over many years. The manager advised him to use his only asset, his farm, as security for his son's failing business. Now, this deal was terrible for the farmer. All risk, no reward. Because of that relationship of trust and the obviously one-sided deal, the court said undue influence was presumed. It was then up to the bank to prove the farmer's consent was freely given, which they couldn't, so the contract could be set aside. Okay, our last stop of vitiating factors is illegality. And this one's pretty simple, really. This is where the law just puts its foot down and says, nope, not happening. It doesn't matter if everyone agreed, if there was no mistake, no pressure. If a contract's purpose is illegal or against public policy, the courts will not enforce it, period. So a contract can be illegal in a couple of ways. Sometimes a specific law, a statute, makes it illegal, like the example here from the Companies Act. Other times, it's illegal under what we call the common law because it offends public policy. This covers the really obvious stuff, like a contract to commit a crime, but also things you'll see in business, like a contract that unfairly stops someone from earning a living in their chosen profession. Okay, deep breath. We've covered a lot of ground. Now it's time to put that knowledge to the test and see how these principles actually play out.
Question 1. Part C Parts Limited supplies chips to Fake Device Co. under a 12-month contract. Midway through, Part C Parts says it will stop supplying chips immediately unless Fake Device Co. pays an extra 20% on all remaining deliveries. Facing stockouts and penalties with its own customers, Fake Device Co. agrees in writing, pays the uplift for 3 months, accepts all deliveries, does not protest, and only after supply stabilizes sues to recover the uplift for economic duress. Which outcome is most likely? A. Fake Device Co. wins. A threatened breach is always illegitimate pressure, so the variation is void. B. Fake Device Co. wins. The variation is voidable for duress. No affirmation occurred. C. Partsy Parts wins. Even if there was duress at the time, Device Co. affirmed the variation by continuing performance without protest. D. Partsy Parts wins. There can be no duress where the threatened act is a breach of contract. E. Fake Device Co. wins. Economic duress automatically gives restitution irrespective of later conduct. Correct answer is C, because economic duress requires illegitimate pressure, causing no practical choice and prompt protest and/or avoidance once the pressure lifts. By paying for months, taking the deliveries, and failing to protest, Fake Device Co. likely affirmed the variation, losing the right to rescind and recover the uplift. A is incorrect, as illegitimate pressure is fact-sensitive. More importantly, the contract wouldn't be void, but voidable. An affirmation can bar relief. B is incorrect, as the facts show delay and continue performance without protest, which points to affirmation. D is incorrect, as this is the wrong statement of law. A threatened breach can be illegitimate pressure. E is incorrect, as remedies are not automatic. Affirmation and causation matter.
And look, because we want you to ace this stuff, here is a mental checklist for any time you see an undue influence question on the exam. Follow these 4 steps. Step 1, is there a relationship of trust? Step 2, is this a case of actual or presumed influence? Step 3, and this is important in banking scenarios, did a third party have notice? And step 4, always remember the effect. The contract is voidable, not void. Okay, before we go, I want to leave you with a question to chew on. Now that you know the rules for all of them, which vitiating factor do you think would be the absolute hardest to prove in a real courtroom? Would it be proving the subtle pressure of actual undue influence, or maybe trying to convince a judge that a complex commercial deal was based on a mutual mistake? Something to think about. That's all from us today. Thanks for joining me